Thank you very much, Mr. President. Mr. President, I stand before this honorable Senate today with a sense of solemn duty and supported by a clear line of judicial authority, not least the pronouncements of our own judges of our Court of Appeal, the Honorable Mr. Justice of Appeal Nolan Barrow, in the case of Francis and the state of Trinidad and Tobago, and former deceased...
Attorney General, 1 second before you begin.
Yes.
There's a minuscule...
yes, indeed. I beg your pardon. I beg your pardon, Mr. President, and please accept my apologies. Would you permit me just to return to my desk to get the paper?
It will be brought to you. 1 second.
Thank you. Thank you, Mr. President, and accept my apologies to you and to the Honorable Senate. Mr. President, I beg to move that a bill entitled An Act to Amend the Jury Act, Chapter 6, Number 53, and the Criminal Procedure Act, Chapter 12, Number 2, and 4 related matters be now read a second time. As I was saying, Mr. President, I stand before this honorable Senate today with a sense of solemn duty and supported by a clear line of judicial authority, not least the pronouncements of our own judges of our Court of Appeal, the Honorable Mr. Justice of Appeal Nolan Barrow in the Francis and the state of Trinidad and Tobago, and former Chief Justice, the late Mr. Justice Isaac Hayatali, in the case of the Attorney General of Trinidad and Tobago and Mutu, whose wisdom has been gratefully adopted and affirmed by the Privy Council in the Surat decision reported at 2007-71 West Indian Reports 391 and the Dominic Suraj decision 2022 UK PC page 26. It is therefore for me, Mr. President, a privilege to pilot before this Senate today this crucial piece of legislation entitled A Bill to Amend the Jury Act, Chapter 56, Number 53, and the Criminal Procedure Act, Chapter 1202, and 4 related matters. I begin by acknowledging that we are here today with this bill to amend an historic, important piece of legislation which already stands tall for its innovative significance, the Miscellaneous Provisions Trial by Judge Alone Act 2017. This 2017 Act, Mr. President, was introduced to allow persons accused of indictable offenses to elect a trial with a judge alone instead of a jury. The purpose of this Act, the 2017 Act, was to address the length of time it took for criminal cases to be resolved and the impact this has on victims, the accused, and states' resources. This Act was passed on the 22nd of June 2017 in the Senate and on the 28th of June 2017 in the House of Representatives by a simple majority, and I repeat that, by a simple majority, and was proclaimed on February 1st, 2019, with the intention of expediting the criminal justice processes in our courts. It was piloted by my predecessor, the former Attorney General, Honorable Minister Faris Al-Rari, to whom I pay tribute. Mr. President, as a result of this 2017 amendment, there have been several completed judge-alone trials to date, with others scheduled to commence. Judge-alone trials have been utilized in several trials for murder and other serious indictable matters. I am pleased to report to this House that we now have a proven operational system of judge-only trials. Correspondence from the judiciary tell us that from February 1st, 2019 to January 31st, 2023, there have been 59 completed judge-alone trials, with 35 now pending. On average, during the year 2022, 2 requests per month were made for judge-alone trials, while 13 requests were made for the month of January 2023 alone. These statistics are self-recommending of the success of the 2017 Act, that requests for judge-alone trials are continuing despite the resumption of trials by jury after the diminution of the pandemic in June 2022. Mr. President, clearly we are on the correct path to continuing the necessary important improvements to our criminal justice system. Acknowledging then the success of the 2017 Act, and for the record of the increasing number of defendants who are electing this mode of trial, it is the legitimate progression that we build further on this success and continue to improve our criminal trial processes, our criminal justice system, with the aim to reduce the length and cost of criminal trials at the High Court, to improve the system for the benefit of accused persons, of victims, of witnesses, and overall to enhance the confidence of the citizens of our proud country that we are continuing to improve the time frame within which all persons impacted are getting justice and experiencing and seeing justice being done in a fair and expedited process, with the aim of reducing our current criminal trial backlog. Mr. President, this bill seeks to amend, therefore, both the Jury Act, Chapter 6, Number 53, and the Criminal Procedure Act, Chapter 1202. It is essentially aimed at reducing the backlog of cases in the criminal justice system by introducing jury trials as the default position for all capital and non-capital indictable matters, with the option for the accused to make an application to the court to be tried by a judge and jury. The bill also seeks, Mr. President, to introduce the utilization of lay assessors whilst repealing the law on special juries and utilizing reduced jury sizes. As most of us are aware, Mr. President, due to the COVID-19 pandemic, many courts in Trinidad and Tobago were necessarily required to cease face-to-face proceedings with certain exceptions. Our situation was not a unique one, as the temporary suspension of criminal jury trials took effect in numerous countries, England and Wales, the United States, South Africa, just to name a few. The unfortunate corollary of this situation was an increase in the backlog of criminal cases waiting to be heard. Mr. President, this government has implemented significant reforms in the criminal justice sector over the past several years in an effort to address the issue of criminal trial backlogs. These efforts have been successful in providing significant relief during the pandemic. The requirements for social distancing and stay-at-home measures were easily facilitated by the creation of divisions of court, electronic payments, electronic transactions, and virtual functioning of our nation's courts. This government now acknowledges that on May 5, 2023, the World Health Organization declared that the COVID-19 pandemic no longer constitutes a public health emergency of international concern. And yet the pandemic provided us with challenges and therefore opportunities to rise to the occasion to implement measures in the criminal justice system which have contributed to improved efficiencies and justify their continued utilization and improvements, such as judge-only trials, which has the tremendous potential to reduce the case backlogs. Mr. President, despite these noteworthy efforts, there has not, regrettably, been a total relief to our judicial system, our criminal justice system, so that we all, members of the citizenry of this country, members of this Honourable Senate, must continue our collective efforts. The statistics obtained from the judiciary show that the criminal case backlog has continued to increase. Data supplied from the judiciary indicates that for the period August 1, 2021 to July 31, 2022, there were 15,152 criminal cases filed at the district courts, including 160 capital matters, 207 criminal cases filed at the high courts in Port of Spain, San Fernando, and Tobago, and 232 criminal cases filed at the Family and Children Division. As of July 31st, 2022, there were 885 criminal matters pending at the High Courts in Port of Spain, San Fernando, and Tobago. 389 criminal matters pending at the Family and Children Division. The data obtained from the judiciary, Mr. President, has also indicated that there are 1,119 defendants in jail awaiting trials. Mr. President, these statistics are concerning. The government of Trinidad and Tobago has implemented significant reforms to address the criminal case backlog, and we recognize that there is more that needs to be done on a continuing basis. Our aim, which we are asking this Senate to join us in, is to continue with all efforts to improve the efficiencies of our criminal justice sector. I take this opportunity to advise that I will be coming back to this Parliament with other measures very shortly. And so, with our commitment to working assiduously to reduce these backlogs, we are here today to introduce and to present this bill. Mr. President, I wish to inform this House that when this bill was being drafted, my office wrote to stakeholders, including the judiciary, the Office of the Director of Public Prosecutions, the ODPP, and the Law Association of Trinidad and Tobago, seeking feedback on the above. The Public Defender's Department itself took its own initiative and provided submissions to my office. All stakeholder feedback, including those parties and entities who I have just named, which were received, has contributed to the quality of the bill before us today. Mr. President, it is important to remind this House that the conduct of jury trials require 12 or 18 persons to participate in a trial for weeks, sometimes up to months, with the possibility of disagreement, a hung jury, and a retrial sometimes being needed. By way of background, jury trials are provided for, Mr. President, in statute by virtue of Section 37 of the Criminal Procedure Act, Chapter 12, Number 2, which provides that if the accused person pleads not guilty, he shall, by such plea without any further form, be deemed to have put himself upon the country for trial, and the court shall order a jury for the trial of the accused person accordingly. Mr. President, we are reassured that previous concerns that the prospect of the removal of jury trials is not an infringement on the individual's constitutional rights. In the Jamaican case of Trevor Stone and the Queen, Privy Council Decision Number 11 of 1978, the appellant there argued that the right of an accused person to be tried by a jury in the case of grave crimes is entrenched in the Constitution.
B, I don't know if the Honourable Attorney General would want to elucidate or clarify a point that he has made.
45(1)B, you said, Senator Mark?
Yes, 45(1)B.
Okay. Honourable Attorney General, he's invoking Standing Order 45(1)B, which asks if the member speaking would give way. Senator Mark, you don't really need to raise the standing order. The precedence is you would just raise and ask if the member would give way, just for efficiency. Member, are you willing to give way to Senator Mark?
I am prepared to give way, Mr. President.
Senator Mark, you may.
Honourable President, through you to the Honourable Attorney General. Honourable Attorney General, can you inform this Senate when these letters were issued to the various stakeholders, and when did you receive responses from them to assist in the final formulation of the bill that is currently before us? And you mentioned a number of them: the judiciary, DPP, Law Association, Public Defender, among others. Can you share with this Honourable Senate the dates that you sent and the date that you received that helped this bill in the way that it is before us? Thank you, Mr. President.
Thank you very much, Honourable Senator. In a perfect world, I will one day be able to claim being one with a perfect memory and fingertip recall. but it's not a perfect world. I do not have those dates at my fingertips, but I certainly can make inquiries and provide them. May I continue, Mr. President? Thank you very much. Mr. President, I was saying when the member rose for clarification that we are reassured that previous concerns at the prospect of the removal of jury trials is not an infringement on the individual's constitutional rights. And that reassurance has been settled by the case out of Jamaica of Trevor Stone and the Queen, a Privy Council decision number 11 of 1978. In that case, the appellant had argued, among other things, that the right of an accused person to be tried by a jury in the case of grave crimes is entrenched in the Constitution of Jamaica, and it can only be removed by the special procedure prescribed by Section 49 of Jamaica's Constitution, and that a Supreme Court judge sitting in a gun court without a jury was inconsistent with the Constitution and therefore void. In that decision, Mr. President, the Privy Council dismissed the appeal and affirmed that a Supreme Court judge, such as our judges under our Constitution and our Supreme Court of Judicature legislation in Trinidad, sitting without a jury is simply a matter of practice and procedure and does not involve a fundamental right to a jury trial by a judge and jury under the Constitution of Trinidad and of Jamaica, which settled principle of law equally applies to Trinidad and Tobago. The current procedure, Mr. President, under the Criminal Procedure Act is as follows. At the first hearing, after an indictment has been filed, a judge informs the accused person that he may elect to be tried by a judge and jury or by a judge alone, unless the accused person indicates an intention to enter a plea of guilty. Where the accused person does not make such an election at that hearing, he must file his election with the Registrar of the Supreme Court and serve a copy on the prosecution within 60 days of the adjournment of that matter or before such later date as the court may order. The court then makes the order that an accused will be tried by a judge alone if it is satisfied, the court is satisfied, that the accused has sought legal advice in relation to a trial by judge alone and has filed the necessary certificate with the Registrar of the Supreme Court. That is the current law which exists in Trinidad and Tobago by reason of the amendment to the Criminal Procedure Act by Act number 17 of 2017, which was passed back in 2017, the Trial by Judge Alone Act. Mr. President, if an accused chooses to be tried by a judge alone without representation by an attorney at law, the court makes the order only in circumstances where the court is satisfied that the accused is competent and has waived his right to legal representation in relation to trial by judge alone and has filed the necessary certificate with the Registrar of the Supreme Court. The court shall not grant an order for a judge alone trial unless it is satisfied, 1, in the case of a joint trial, all other accused persons have elected to be tried by a judge alone, and each such accused person has filed a certificate in the appropriate forms set out in the first schedule to the Criminal Procedure Act. And secondly, where 2 or more charges are to be tried together, the judge must be satisfied that the accused person has elected to be tried by a judge alone in respect of all of the charges. Mr. President, I wish to inform this House that the accused person may subsequently apply to the court for a trial before a judge and jury or vice versa within a stipulated time. One of the main benefits, Mr. President, of a judge-alone trial is that as soon as reasonably practicable and in any event, before the expiry of 14 days, the judge must deliver his verdict. May I repeat that? As soon as reasonably practicable under the legislation which exists now, the Trial by Judge Alone Act, which we are seeking to amend in limited respects, as soon as reasonably practicable and in any event before the expiry of 14 days, the judge must deliver his verdict. And in the case of a conviction, give a written judgment stating the reasons for his verdict at the time of conviction. The prosecution, in the case of an acquittal, may make a request for the judge to provide reasons for same, in which event the judge may give reasons within 14 days of that request. This is not the case in a trial held before a jury and is of substantial benefit to the accused, to the victims, and the entire criminal justice system. Because what this piece of legislation is seeking to do and is serving to do and demonstrably has been doing since it became part of our law is to provide for a more expeditious criminal justice system, something which I do not think that a single woman or man on the streets of this republic would suggest is not a desired objective. Mr. President, I wish to highlight some additional benefits to the use of judge-alone trials. It reduces the length of time a person has to wait for a trial to begin, as there is no jury selection to be done. This process can be quite lengthy and challenging, as oftentimes persons do not come to the courts willing to be called as a juror, but rather a greater percentage of persons present reasons to support why they cannot serve as a juror. I recall, Mr. President, when I was a very young practitioner, and I was being led then by one of the most able practitioners that this country has ever produced, Mr. Frank Solomon, Senior Counsel. I was deviling work for him in a matter, I won't call names, that involved some very heinous criminal offenses in this country. And it took several months in which to empanel a jury because jurors were scared. The respective public officials commissioned by order of the judge literally found jurors on the beaches in Chagaramas to come to the trial which was taking place in a specially constructed court in Chagaramas for that particular murder trial, one of the most heinous murders that this country has ever had the misfortune to experience. The trial itself, Mr. President, can be concluded in a shorter time frame. I've just given an example of those time frames. And additionally, the state is able to save the resources which would otherwise have to be spent on empaneling a jury, including their alternates. Based on the successes, Mr. President, of the 2017 legislation then, this bill before us today proposes judge-only trials as the default option for all indictable matters. The bill further provides for the utilization of lay assessors with special expertise and qualifications from a pool of assessors inclusive of attorneys at law, and the repeal of special jurors provisions in the Jury Act, which has never been used in Trinidad and Tobago. And a summary, Mr. President, without belaboring the point, of the benefits which will be obtained from the amendments that we are seeking to produce today if this chamber were to endorse the government's efforts, is the amendments to the Jury Act and the Criminal Procedure Act. A, the utilization of judge-only trials as the default option for all capital and non-capital indictable matters, with the option for an accused person to make an application to the judge to be tried by a judge and jury, with the judge always being reserved the discretion to determine how that trial shall proceed. That jury trials be conducted with a reduced jury size. C, the utilization of lay assessors with special expertise and qualifications from a pool inclusive of attorneys at law where the accused person elects lay assessors or where the judge deems it necessary for any indictable offense except an offense punishable with death, and in particular, any indictable offense involving fraud. One can think of trials coming under the Proceeds of Crime Act, trials coming under the Anti-Terrorism Act, trials under the Economic Sanctions Act, orders made under the Securities Act, and any other written law in relation to the prevention of money laundering, combating the financing of terrorism, and the proliferation of financing. This amendment that we are bringing to the House today, to this chamber today, will enable the judge to appoint lay assessors where the accused has opted for a trial without a jury, so that those lay assessors in specialized fields of endeavor can assist the judge in coming to a proper and fair trial. And of course, lastly, the amendments that we seek to bring will involve the repeal of all provisions relating to special juries, a facility which has never been used in this country. Mr. President, I will not belabor the point. We will be going through the clause, the bill, clause by clause. I take this opportunity to thank you and to place on record this government's commitment to reducing the backlog of cases that are currently plaguing the criminal justice system. The passage of this bill will be used as another critical mechanism through which matters can be disposed of quickly and without any compromise to the accused. Are you willing to
give way? AJ?
Are you willing to give way, AJ?
I am willing to give way to Senator Mark.
Through the Honourable President, may I ask the Honourable Attorney General, can you explain and offer a rationale for the inclusion of a provision or a clause to allow the Attorney General to add to the list of offences, indictable offences, that are outlined in the said legislation? Can you share with us, Senate, what is the rationale for the insertion of the Attorney General in this particular piece of legislation?
I would ask you to particularize that in greater detail, Mr. Senator Mark, and I'm quite prepared to address it in my wind-up.
That you have inserted. So all I'm asking the President, for you as the Attorney General, to explain to this Senate and to Trinidad and Tobago, why have you inserted the Attorney General to add to the list of offences subject to an affirmative resolution? You must have a rationale.
Can you point me to the section that you are referring to in that case, please? I would rather be specific as opposed to being generalized.
Are you about to wind up?
I am about to wind up.
Yeah, can I see the legislation so I could just point out to the can I see this?
So just one second. Take a seat, Senator Mark. Members on my right, please. Attorney General. So this process is all normal and it's all allowed as per the standing orders. The Attorney General has more time in his contribution before he has to end and utter the words that need to be uttered in order to move this procedure along. Senator Mark, if you're ready for him,
I'm ready.
Raise and indicate to the Attorney General what it is you're referring to.
Honourable Attorney General, if you go to page 8 of the bill that I have before me, it is subsection 3. It comes before clause 6D on page 8. It reads, the Attorney General may by order, subject to affirmative resolution of Parliament, amend the list of offences referred to in subsection 2. So you have a list of offences, including misbehavior in public office, gambling and commission, all of these things are here. But this particular section, where the Attorney General has inserted himself, I'm just trying to get a justification and rationale for that particular insertion. Can you share with us, Honourable Senate?
Thank you very much, Senator Mark. And I, of course, benefit from your precision by pointing me to the particular subsection. So I understand you to be pointing to the amendment that will be brought in under lay assessors, and you are referring to the new proposed section 6C, subsection 3. It would not be correct, Mr. Senator, to say that the Attorney General has inserted that to allow himself, because in the first instance, this legislation, as I have sought to indicate, has been drafted through a very careful process that has involved consultation with stakeholders. It has been drafted through the office of, in the first instance, Law Revision Commission, setting out the policy, drafted through the office of the Chief Parliamentary Counsel, and then went through a detailed process before the Legislative Review Committee, taking contributions from relevant stakeholders. Yes, it is correct that there is provision made in Section 6C(3) that the Attorney General may, by order, subject to affirmative resolution of Parliament, amend the list of offences referred to in subsection 2. The rationale for that stems in the first instance from the function, the constitutional function of the Attorney General pursuant to the provisions of the Constitution, in particular Section 76, where the Attorney General is responsible for the administration of justice. The rationale for that, secondly, and I think that this bill is a good example of precisely that rationale, in which we have to keep our laws under constant review as our society evolves and as circumstances develop. And if, in the review of the society's evolution and the occurrence of circumstances arising from time to time, it is, in the opinion of the Attorney General, a circumstance that needs to be added as an offense, the Attorney General would send a question in that regard to the Law Reform Commission, proposing a particular offense, ask for a policy report on that, which will then be discussed in Cabinet. It may or may not be accepted. After, assuming it is accepted as a policy decision that the Cabinet has approved, it will be taken to the Chief Parliamentary Counsel, who will draft the requisite piece of legislation to introduce that particular offense. It may have to do with a particular aspect of cybercrime, which is a fast evolving area of our reality that we have to keep pace with. And if at the end of the process, a detailed, careful process, the Attorney General is satisfied by the advice that he receives that this offense needs to be added to the schedule of offenses, then that is added to the schedule of offenses in an attempt to keep our laws under review. And very critically, and you have no doubt with your experience would recognize this, very critically, that proposed amendment by way of an offense added to the schedule will come to this Parliament for debate by way of an affirmative resolution, so that the Parliament is satisfied that what has been done is proportionate and satisfies a legitimate aim. I hope that I have sufficiently addressed such concerns as you might have, Senator Mark. Thank you, Mr. President. I was in the process of saying that I take this opportunity to thank this chamber and to place on record this government's commitment to reducing the backlog of cases that are currently plaguing the criminal justice system. We have before us the bill, which we will be going through clause by clause, and I will endeavor to assist members as we make and undertake that exercise. It is a critical piece of legislation to improve our criminal justice system so that matters may be disposed of quickly and without any compromise to the accused's constitutional right to a fair trial. I wish to express my gratitude for the submissions and contributions which we have so far received to this bill, both in writing and orally, and these contributions have helped to ensure that as a government we have produced a bill that is constitutionally sound and which seeks to improve the criminal justice system in Trinidad and Tobago. Mr. President, with those remarks, I beg to move.